A lot of Indian American families in Texas are setting up revocable living trusts, and I think that is a smart move. But here's the thing, if the trust is not set up properly, then that could just defeat the purpose of setting up a trust, and your family could end up in probate court, which may be one of the things that you are trying to avoid to begin with. Here are the top three mistakes that people make when setting up a revocable living trust. Mistake number three is that they don't fund the trust. So while they are with the attorney sets up the whole trust for them, he drafts all the documents for them, and then he tells them that whatever assets you own, you need to retitle those assets in the name of the trust. So basically, if you own a home in your name or in joint names of you and your wife, then you need to retitle that asset in the name of the trust. So you will say, as the trustee of the trust owns the property. Practically, it has no difference during your lifetime. You're free to change it, revoke it. You still exercise full control over it. But it is important that you retitle the asset. Think of the trust like a box. If there's a box in which whatever assets that you put in the box, they avoid probate court, and you can seamlessly transfer them to your kids. But if you don't retitle assets in the name of that particular box, then having the box does not make any sense to begin with. So mistake number three, which is the most common mistake that I see, is that people don't retitle assets in the name of the trust. Mistake number two is that people think that if you set up a revocable living trust, then you get asset protection or protection from creditors to the extent of the properties that you've put in the revocable living trust. Now, that is simply not true, because in a revocable living trust, what happens is when you put the assets into the box, you still exercise a lot of control over the properties that are in the box, because so in a trust, there are three parties. You have the grantor, you have the trustee, and you have the beneficiary. Grantor is the person who puts the property into the trust. Now, during your lifetime, you are the grantor. During your lifetime, you're also the trustee to the trust, because you manage the properties that you put in the trust. During your lifetime, you're also the beneficiary, because you also enjoy whatever income or all the benefits that come with the property. So you are all three. So you exercise serious control and custody over the properties in the trust. So for that reason, you do not get creditor protection for the properties that are put inside the trust. Now, on the other hand, if you were to transfer these assets to an irrevocable trust, which is a separate topic altogether, then maybe you could argue that there should be some form of creditor protection. But for a revocable living trust, you do not get any creditor protection. Mistake number one is that your trust does not override the beneficiary designations that you have put for your life insurance, for example, or your retirement accounts. So if you have, Mr. X who takes under your beneficiary designation, and Mr. Y who you give your life insurance and your retirement accounts in the trust, then the beneficiary designations control, and the person who you name as the beneficiary of that particular policy, they will take. So it's important to make sure that there are no contradictions between what you write in your will or your trust versus what you write in the beneficiary designations, and they need to go together to form a comprehensive estate plan. Follow for more estate planning tips for Indian families in Texas.